If you've made it this far, you've covered the three essential elements of showing whether someone has been negligent, that they owe a duty, that they breached a duty, and that that breach caused the harm. Once we've hit this point, though, we still have not established the level of liability of the defendant. How much will they actually have to pay in terms of the damages? To deal with this, we've got to turn our attention from the defendant to what the plaintiff actually did. How does their behaviour affect the outcome of the case? And more formally, we do that by looking at two defences, voluntary assumption of risk and contributory negligence. So let's have a look at the first defence, voluntary assumption of risk. So voluntary assumption of risk is based upon the idea that if someone knows what they're doing, if they comprehend the risk they're taking, and then freely choose to accept it, then no one else should be liable for the harm. They should bear the consequence of their decision. This principle is a long-standing one in the Anglo legal tradition because it's trying to reinforce this freedom to choose and individualism. If individuals did not have the right to choose, then what we'd end up with is a situation where other people would actually be trying to force others to behave in a certain way. So if we put liability onto someone, even though the other person chooses to take that behaviour, that person shackled with the liability is not only facing an unfair situation, they're going to actually try and stop the person doing what they want to do. And a key thought behind the Anglo legal tradition is no, people should be free to do whatever they like. That brings us to this assumption of voluntary assumption of risk. So wherever the plaintiff is fully aware of the specific risks they're taking, that means they understand the nature and extent of the risk, and they voluntarily, that is freely and willingly, accept that risk, then the defendant will not be liable. That is, they'll still be negligent, but they won't have to pay any damages. Now, this sounds like a very attractive defence that you might try and use in a negligence case, but I really want to stress it's a very difficult one to make out at law. Why? Because it's largely a subjective test. You must show that that person was fully aware of the risk and fully appreciated the nature and extent of the risk, which can be quite difficult to show. Why is it so difficult to show? Because it is difficult to show that someone knew anything beyond kind of these generic general risks. So I've got an example here from jiu-jitsu. Like, clearly if you go to jiu-jitsu and you know anything about jiu-jitsu, you know that you risk being choked unconscious, for instance, for a short period of time. But you might not know the extent of the risk that you're going to take. For instance, that with some people it might, collapse an artery, or that there might be other behaviours that occur, such as slams or being struck or kneed that occurs as a natural part. But if you're new to jiu-jitsu, for instance, you might not understand that. And so you don't know about that risk, then you take it. So while you might say someone's aware of physical risks when they take on jiu-jitsu, it's not that simple. It has to be the actual risk, and that you can show they knew about that specific risk that they were taking when they did it. And that's a lot harder to do than what it first sounds. Because it can be so difficult to show that someone knew about the risk, particularly if they're not going to tell the truth, the Civil Liability Act has gone some way to try and increase the availability of this particular defence. In these situations, I think the Civil Liability Act was responding to certain contexts. For instance, adventure sports such as bungee jumping, etc. If you're going to bungee jump, there's some obvious risks that are involved with that. Or if you're going to do jiu-jitsu, there are some obvious risks. You can't just say, I had no idea I was going to be choked. It's obvious you're going to be choked. So the law introduced Section 14. And what does it try and do? Section 14 tries to reverse the onus around obvious risks. What are obvious risks? Risks that a reasonable person would foresee in that particular situation. So if a risk is obvious, then what we get is a different test. It's assumed the person taking the risk knew about the risk unless they can prove that they didn't know about the risk. So it is trying to incorporate those obvious risks into the defences for negligence. Again, I don't want to overemphasize this part. I would rather leave you with the impression that it's often super difficult to show that someone understood the nature and extent of the risk that actually causes them the harm, which is why it's such a difficult defence to make out. But having said that, if you can make it out, it means that the defendant does not have any liability. Why? Because the plaintiff assumed liability. They consented, they knew about the risk and took it anyway. So therefore, any harm that happens is on them. In a similar way around things like adventure activities and adventure tourism and sports, Section 16 tries to limit some level of liability and negligence by saying that defendants aren't liable for inherent risks. Inherent risks are risks that you can't get rid of. So for instance, if you're skydiving, you could take all of the mitigation measures that you possibly could, but you just can't control the wind and downdrafts. So there's always a risk you might have a hard landing. So these inherent risks do not form part of your liability as a defendant. So I don't want to stress this particular defence. I think it's quite hard to make out. The law has tried to clarify some areas around obvious risks and inherent risks, but I think it's important to recognise that making out a defence of voluntary assumption of risk is quite difficult to do. You're far more likely to have some success around the other defence that's available, contributory negligence, which is the subject of the next video.